he's not plucking his feathers and he's eating these turkeys, he's okay. And now everybody that listens to Rogers will know that. Giver is not plucking his feathers. So he's happy.
They need to know all these things. Grounded education.
When I can do it, it's right.
I'll help you out. Don't laugh too
Not
hard.
only the cases, what is some of the sections so I can make sure I remember? Is it 9 or 8? 9. So we're on section 9, and we're going to do our cases. And we're also going to talk about, I think it's the discovery rules as well. Am I correct? And what I want to do, though, is, because I think they're that important, I want to separate out the first group of cases with respect to personal services, which are the traditional personal services cases. So that'll be Warner Wolf, Red Grave, and Florida Panthers. And I want to say for next time the wounds for rent and the what I call the modern contracts for personal services, the Johnson versus Calvert, the Culleton case, the questions concerning assisted reproduction. I'm going to put on some more stuff online for you to take a look at. Lena was nice enough to get us some material with respect to reproductive technology and agreements and the like so that you can take a look at. Because what I really want you to think about, and we'll do it when then the week we come back, so we'll split up that section 10 between the end of these cases about surrogacy and the like and the beginning of the other issues related to family and the like that we're going to do. But I want you to start to think about how you're going to try and work these agreements and potentially worry about enforcement, and what provisions you may write into there and what you think is lawful and what isn't. And depending on the state we're in, there's also additional legal issues with respect to not only what you could write in the contract, but what are the preconditions to enter such a contract. You know, you may sit here now and say, well, I'll probably never end up being involved with one of those, and you might think that, but that's not likely these days either. You know, many years ago, I was involved in writing up one of the agreements, and I wouldn't have thought that when I was sitting in law school that would happen, and that was way before technology has advanced to the point it is. So whether it's you're involved in the beginning of that process or you're involved in the end of it when things are breaking up and now we're fighting about what the rights of the various parties are and the like, I think it's very important to start to think about those issues and be prepared to deal with them. And usually, by the time we're done, someone either in this class or online tells me that, you know, they've already been involved in issues related to this. So imagine there are more than one as well. So I want you to think about those cases, and I want to give them enough time because I think there's significant amounts of issues, both legal and ethical and litigated issues that you should be cognizant about. So tonight we're just really going to look at the traditional personal services contracts, which really are at odds with this other type of personal service contracts, I think, when you start to think about them. But I want to talk a little bit about the discovery issues first, because in civil cases, cases are won and lost through discovery. And I was just thinking as I walked in the door, actually, is the same thing should be true and should be capable of being said in criminal cases, because I think, again, it is. But my experience is that whether they're the DA or the defense attorney, they do not use the few criminal discovery rules that are available, and there are some, to maximum benefit. I think the better attorneys that I've seen that do criminal litigation have in fact used the discovery process that exists there to be able to have effective trials and to be able to use it to either keep evidence out then if it's not turned over timely, or if there are problems with the foundation for that evidence when you have an opportunity to examine it. But I think it's an area that should be explored much more aggressively if you do criminal law. But especially in civil cases, your discovery process may take maybe 12 of the 18 months you're doing something. And you may do a little bit of discovery, interrogatories, a few depositions, or you may run around for months and months doing discovery. So and more often the latter is true than the former. More often that civil cases are dominated by discovery, and I recommend, and I haven't effective one together with the professor to teach it at this point, is that you try and take a discovery practice course before we leave here. We've offered it a few times, but sometimes it fills and sometimes it doesn't. But if you intend to do civil litigation, you really need to learn exactly how discovery works, because that's where the cases are won and lost. But let's talk a little bit about what you can get in discovery. Scope of discovery allows you to access non-privileged material, first of all, right? So that if material is privileged, that doesn't have to be turned over. But beyond non-privileged material, what you're allowed to get is not just what is relevant, not just what will help to prove or disprove facts of consequence of the litigation, but anything that may lead to relevant evidence. So the pond you're allowed to fish in is not insignificant. And you know, a lot of attorneys try to oppose discovery on just that basis, saying, Your Honor, it's just a fishing expedition. They don't know what they'll get. And frankly, a lot of times, I don't know what I'll get. But I know what I'm looking for, and I know if what I'm looking for is either relevant or will lead to relevant evidence, then I'm entitled to get it, as provided it's not privileged. And the fact is, we've got various methods of obtaining discovery, and unfortunately, this is where a lot of the abuses come in, where attorneys do not readily comply with discovery or withhold information under phony claims of privilege or phony arguments about it not being sufficiently responsive to your request and the like. And so we have a lot of disputes over it. And the fact is that the court polices those disputes under Rule 37. Rule 37 allows the court to issue orders requiring people to produce the information that was sought. And it also has the ability to provide for sanctions if that information isn't timely produced. Now, just because you ask for it, though, doesn't mean I'm going to give it to you right away. And I may be prepared to test your resolve in trying to get access to it, especially if I think it's really damaging. So it's not, I have a saying, it's not the first box of documents you get that's important, it's the last box. It's the one you continue to push for. It's the one you argue about, because a lot of lawyers will try to be less than forthcoming in the process, is the nicest way I can say it. And other attorneys will out and out cheat in that process and not turn over the information in a timely fashion. So you've got to be prepared to inspect things carefully. But first, what you've got to be prepared is to make an appropriate request for that information. A couple of the things that we use for discovery: interrogatories, written questions to the other side. Not always that effective, because if I give you a question today and tell you you have 60 days to answer it, the likelihood of getting some great damaging admission is relatively low, especially where your attorney is the one that prepares those interrogatories and ultimately has you sign. However, it is a good method of fixing a party's claims and fixing their position, right? Because at least if I write those interrogatories sufficiently carefully, then I will be able to pin down your story so that I then can attack it later on down the line, both with other methods in that trial. But it's relatively cheap, right? All it is you write up questions, you submit them to the other side, they have to answer them, sign them under oath, and you get some sworn testimony back. But not always effective, because the attorneys help shape the words that he used. Be careful how you do, because I'm going to use those when I do a deposition. I'm going to interrogate you as to whether they're accurate and the like. So if you're the attorney, you want to make sure that you don't overplay your hand either. Requests for production of documents and things. Very, very heavily used in discovery. Again, your wording on what you want has to be sufficiently clear and precise. I used the illustration, if you ask me for the red notebook and the notebook's maroon, and I think I am an honest and ethical attorney, you're not getting the maroon one. You didn't ask for that one. You asked for the red one. I know you want the maroon one, but you didn't ask for the maroon one. You didn't ask for the documents from 2008, you asked them from 2009 forward. I'm not going to say, hey, go back another year, right? So that's partly, that's on you, right? You ask for what you want and make sure your language is clear. That's what we're supposed to be doing. That's what we're hopefully helping you learn to do, is be more precise. precise with your language. On the other hand, there are times that people will ask for the red notebook. You've got a red notebook, and they say, well, it's not really red, it's cardinal. Well, cardinal's red, isn't it? And that to me is cheating. Okay, so I mean, you've got to be careful with that, because I am going to push, and sooner or later, hopefully I will get access to it. And now you look like a cheat, and you look like a huge lawyer back there, and you're tarnishing yourself as well. So you want to be careful. There's a fine line between zealous advocacy and not being appropriately ethical in discovery. And it's unfortunate, but a lot of people blur that line. And I think it's irresponsible and unethical, but it happens way too much. So your request for production of documents and things, I get all of these things from parties, by the way, both interrogatories and request for production of documents and limited to parties. I get all this information, then I've got to do something with it. And that's the other part about request for production of documents is there's a question, not a question really. You want it in paper form still? You want it on some type of digital media? I'm not sure. I wouldn't rather have paper anymore. If it's stored in digital, give me it on a thumb drive or a DVD, and I'll leave, and that's not going to cost anything to produce that, really. You want the cost of the DVD or the thumb drive, I can do that. If it's stored in paper, someone's got to pay. And so if you want my staff to be hanging around copying stuff for you, what are we talking about, 10 cents a page, 15 cents a page? Someone's got to pay for the costs of producing that in paper format. In a small case, that's negligible. In a big case, that's not insignificant. And I've seen folks try to charge as much as 25 cents a page. Well, 25 cents a page, and again, I think in part it's to discourage the litigant, 25 cents a page with that date stamp number on it. And sometimes we will stamp the discovery so it's clear as to where it came from and what the source of that document is, and we can keep track of it. Bigger cases, we tend to what we call stamped, and actually now you can do that through Adobe as well, which will produce the information either in paper or electronically with a number on it as well. So again, it's relatively inexpensive. There are inexpensive ways and expensive ways to deal with the documents and information. And it's not, and all of that is stuff you need to start to think about, because it's not just, okay, I've got the paper, now what do I do with it? Because now I've got to read it all, and I've got to try to manage it somehow. And again, I've had cases with a few documents, which still would be hundreds, right, generally, to hundreds of thousands. And there's a problem when you have to manage that type of papers, and papers specifically. Again, though, start to think about how you can use technology to help manage your time. You know, I mean, if I get it electronically, I can search by word. I can do a lot of things a lot more efficiently. You know, that's still at the end of the day. Oftentimes, it helps to turn the page and see how things were maintained, if they were. But you need to think about all these issues as you start to figure out about discovery. So I get all the information through request for production of documents and things. Now, and that's the usual order. The next, I'm going to start to look at depositions. I'm going to now call witnesses in. Depositions can be used with anyone. And I'm going to call them in, and I am going to try and discover information and start to create information that I can use in trial. By that, what I mean is evidence for impeachment purposes and evidence for laying foundations and to prove my case through the use of those depositions and the documents I received prior to. If the documents that I got on a request for production of documents, as I told you, that's limited to parties only. If I want to depose Fiona and I think she's got documents of things that I would like to examine, I can still depose her as a non-party, and I can serve a subpoena on her under Rule 45 and request that she come to that deposition with certain documents that may be in her possession. For instance, if I wanted to prove your text messages or cell phone calls after having deposed you and found out who your cell phone provider was on whatever the date was, well, then the likelihood is I'm going to subpoena your AT&T provider, and I'm going to ask them to bring all records pertaining to your cell phone and landline for a certain period of time. And these days, I'm probably going to hit the mother lode with with your cell phone. And hopefully grab your text messages while we're at it. And that I might not need much more than that. And so that's what you have to start to think about with Discovery, as well as the technology, is how are they communicating now, and how can I gather that information? Because you may not you don't print off all your emails, obviously, so you may even have it in paper, but I certainly would like to see all your emails that are on either your desktop, laptop, or even cell, so that I can look at the information. I'm not going to get them all necessarily, but I can ask for relevant information that pertains to your auto accident, or even a simple auto accident now. Don't you want to get access to the cell phone to see if they were on it, either texting or talking at the time of the collision, or not at the time? What did they text immediately after with respect to what happened? All of that obviously would likely be discoverable, and I'm probably going to get it once I know who your provider is, by subpoenaing in the provider and asking them to bring the records with them, and then examining your cell phone records and text messages to see what exactly took place. I can depose anyone, not just a party, and I can request non-parties to bring certain documents and things to that deposition. Requests for admissions are usually used closer to trial. Again, they're limited to parties only. And what we're trying to do there is narrow the issues for trial, sort of take off the table some of the legal issues that are involved in the discussion. And usually that requests for admissions are best used with respect to experts and the like, to try to get you to acknowledge those facts that I might otherwise have to spend some money on trying to prove. And that may shift the cost of that expert if the court later determines you should have reasonably admitted what I requested you to admit through request for admissions. So we've got requests for admissions, interrogatories, requests for productions, parties only. We've got depositions that are, again, any witness can be deposed. And then lastly, we have requests for physical and mental exams under Rule 35 when the physical and mental condition of a party is an issue. Party or an agent of a party is an issue. And we're going to fight about that too, for two reasons. A, no one wants to have their body or brain probed. And certainly not by strangers, certainly not by someone they didn't pick. And that's generally what a request for mental or physical exam means, is by my person, because I doubt the veracity of what you're saying. The other thing we're going to fight about is, I want to limit, A, how long you get to do that exam, and who is going to be involved, how many people can be involved in that exam. Again, because I'm looking at it geared to trial, best case, my first cross-examination question could be, you only examined them for an hour, right? You're not a treating physician, correct? No. And so your examination was limited to a total of 60 minutes. And so at the minimum, the less time I give you access to the person, the better my cross-examination goes, even if you find exactly what I expect you're going to find, is that it fully supports what the other side's version of the story is, right? So you have to start to think about that. The other thing is, I want to limit it to a person, because then you only have one person testifying as opposed to two. They wanted to have my guy examined by both a psychiatrist and a psychologist, two different people at two different institutions, major institutions too. And then they wanted to do it for a total of 10 hours. So all my cross-examination questions go down the tubes. So we fought about who and how long you'd have access and all the rest of it, because while it authorizes an exam, the rest of it, we have an ability to argue about the conditions under which that's taken. And that becomes a real item of contention as to what that information I can get access to, or you can get access to in that process as well. So even though the rule provides for it, it's not a given as to what the rest of the parameters are. And so you need to start to think about that as you start to think about being an advocate and shaping your case. I think one of the best things you can do if you're not going to take the class, or if you do take the class, is really start to look at Rules 26, which provides the scope of discovery, all the way through the end of discovery is Rule 37, which provides for sanctions, and really start to think about what those provisions mean. Because again, if you're going to do this type of work, you need to know exactly when people go too far and when they go too far, what my options are. And again, I've told you in different contexts, the lawyer that knows the rules better than the other is more likely the victor than the person who just sort of, some student said to me today, oh, I like having this other professor. All we have to do is sort of generally know what the law is with, well, we'll say with this, we'll say with me, we'll make it me. With you, we have to know exactly what it says. And I don't know how, if you don't know exactly what it says, you can really make an effective argument, because at the end of the day, lawyers are arguing about the nuances of it, aren't we? And you have to know the law with some precision if you're going to argue it. And to sort of know it generally sounds to me like you don't really know it. And that's the way these rules work as well. If you start to look at them, you can see, okay, if a party goes too far, I can suspend the deposition. I can move for costs if I think it's been done for harassing or annoying purposes. And at the minimum, I better know that language, because if I think you're doing that, I'm going to start peppering the deposition with that language and telling you, if you keep it up, we are walking out. And I know, because the rule provides, that we can do just that. And all I'm doing now is establishing my record so that when I do walk out, I'm not going to be the one getting tagged with costs, or at least I have an argument as to why I shouldn't be. And frankly, you know, again, we've talked about this, it's not a good part of our profession, but there are a lot of bullies, and there are people who will simply attempt to take advantage of your inexperience, and the way in which you ensure that that isn't done is by knowing your rules and how it works better than anyone else. And if you do, the fact is you don't have to worry about anyone. And you'll be surprised how being able to do that will put you in the top half instead of the bottom half very quickly, simply because there's a lot of people that get lazy about it. So I would strongly suggest you look at them carefully and understand what you can do. I probably get a question a week, either by phone or someone in person, about, well, they won't do this with discovery, or they won't give me this, what can I do now? You know, and someone, I got to answer, someone sent me a thing, an interesting question, and I've asked it before to you guys. They want to know, is there any rule that now provides for service by email? Well, it might be nice, but frankly, you could look at Rule 4 and figure that out too. So look at usual rules and understand what they mean, and you're more likely to be successful. From the standpoint of bragging on your classmates, I should tell you that invariably when they go to these competitions, Stephanie was there this weekend and was outstanding, by the way. When they, she really was terrific. The whole group of them were terrific, but she did a great job. And when they go, invariably they know the rules better than other schools. And I mean, there were some arguments made that other good schools, not made, that just had complete misunderstanding of hearsay and some other issues. You know, and said it still with confidence, so the judge doesn't know either, because judges don't always know it either. But you know, still, you don't have to worry when you do know some of the arguments, and you can make them, and then just have confidence in what you know. And confidence comes from having done the work that you guys are all doing. So, questions on discovery? This is where civil cases are won and lost, and that's what you need to know. And all that often requires you to do is just work harder than anyone else. Questions? And you wouldn't be going to law school, this law school certainly, if you weren't prepared to work harder than anyone else, right? We good to go? No questions on discovery? We can get a good course. Would you take it? Absolutely. You're shaking your head no over there? Why not?
Well, just me personally, because I do a lot of interrogatories, responses to production documents, depositions, everything.
So you have you understand how at least the nuts and bolts work at this point?
Yeah.
Okay. What about you? You said
I'm
too.
in the same boat.
Yeah, I know you do too.
It would be a good class to have, because I think like just throwing yourself into it, it can be very overwhelming.
Have you guys sat in on depositions as well? Oh, you have, so you've seen all of those. How many of you have ever seen a deposition or been a party to a deposition? Oh, wow. That's a pretty big number. You guys get sued a lot, huh?
Into society.
No, obviously. I really wouldn't have guessed that number. That's interesting. Okay, let's do our cases though as well. And so what we're looking at in this group is ABC versus Warner Wolf, Vanessa Redgrave, and Florida Panthers. And these are all contracts for personal services. And then the enforcement of those contracts. And the problem comes in traditional personal services contracts, what happens when we breach? Or what happens when someone breaches? Can you get specific performance of that contract? Can you really ask for the court's intervention to get what you had bargained for? And so let me ask you about ABC versus Warner Wolf, because I think there's a bunch of different ways that you can look at this. But let me start out with always one of my favorites. So Warner Wolf's lawyers, just sleazy or really clever? I mean, is this good lawyering? Well, we had a provision, all we needed to do was figure out the workaround. And they did. And they got their client a great deal, did they? So great lawyers are sleazy. Who's going to dip their toe in? What?
Sleazily clever.
Sleazily clever. You're going to walk the line, huh? I mean, if Warner Wolf came to you and asked you, okay, listen, I think I can get a good deal down the street, but I gave these guys certain rights in the last contract when they were building me up and making me good money. Go ahead, Geneva.
I think it's good lawyering because what we learned in contracts is that everyone breaches, basically, and
let me guess who taught you that.
And so, I mean, the best way to go about it is to figure out, you know, how you can get around it, like what a good way of breaching is. So.
You all on the same page?
No, I found it.
Go ahead.
I don't understand why he didn't go back to them and say this is what, and that's what I would advise my client. Why do you have to do something unethical and breach the good faith? You know, the part of your reputation in any place is that you honor a contract if you can. And all he had to do was go back to them and say, listen, this is what I can get. Will you do it as well?
Well, except it sounded like he didn't want to do it for them anymore, right? So I mean, he really did sort of want.
Right,
but go ahead, yeah.
But I believe in that he should have, you know, that he should have lived up to that good faith provision.
Geneva, you really think you and your client were acting in good faith? I mean, did ABC get what they had bargained for here?
Well, they already threw out half of ABC's argument. So, I mean, I just think that he was strategic in what he did. And
so he had what,
he had 2 claims.
No, but so they had to, he had a 60-day, you can't bargain with anyone else in the last 60 days of the contract.
And if he gets an offer, then he has to go back to them. They have the
and
right
he gets an offer during that period.
And they have the right of first refusal.
They had a right of first refusal.
So he
negotiated the deal 65 days prior to termination, right?
Right.
And that's okay. If ABC had lawyers, if they wanted a different deal, they wanted a exclusive negotiation during the whole period, they should have said that. They didn't say that. They said only during the last 60.
Right.
Wasn't the intent of the parties otherwise than that I mean, because you sort of done away with my 60-day exclusive negotiating provision here and my right of first refusal, no? Because he's going to be a producer somewhere else or whatever. I mean,
yeah,
so you really
yes.
cleverly manipulated your way around the terms of the agreement. But that's what we do. Is that
right. He did it all. What he did was, because the agreement took, it was after, he went back to the period where he could talk to another company rather than that 90-day period.
right?
It was
So he just started early.
It was a technicality that he used to his advantage.
Well, is that a technicality, or is
Well,
that really
it was-
sort of finding your?
Yeah, I can't, the appellate judge, Cook, in this case, said it was a simple, although serious breach of general contract negotiation. However, to enforce that would interfere with an individual's livelihood and to inhibit free competition. So, I mean, I think it's very clever lawyering. I mean, in effect, I mean, ABC essentially gets screwed and CBS, or vice versa, CBS gets them as a sportscaster. But, I mean, it's very clever. I mean, it was upheld by the...
So you would, and it was, well, it was upheld because, what is ABC? ABC wants to get him back.
Yeah, they're just trying to force him to be a sportscaster. They're trying to force him into being...
For them.
For them.
Why can't we do that?
It's just competitive edge. It's what it is. I mean, they want him there because he's a big name, or he's someone that's recognized.
Well, he's a big name now because I built him up over all these years. And now he just says, see ya, and doesn't honor the terms of his agreement, and I can't get him back.
You can't do it, it would be served to.
And with monetary
Okay.
damage.
Okay, well, come to monetary damages. I can't force him to honor the terms of the agreement, negotiate with me, and get a job here. Right? Right? I can't enforce the personal service contract. Why not?
You can't force someone to work.
But that's what we agreed to do. What would be the problems with enforcing that type of personal service contract by way of an injunction or a specific performance? What do you think? You must have learned this. I hope you learned this in contracts, because this is what you should have learned. Correct? Some of you.
In constitutional rights, like
What?
servitude.
But you sort of gave up your rights on that.
Yeah, but
Is
there's
that what
no-
it is? I mean, we're saying, oh, this is unconstitutional because it's
But there's no
involuntary servitude. It's not it wasn't involuntary. You agreed. This is the provision. You would work with me for a year for X number of dollars. That wasn't involuntary. That was voluntary when you signed that. Now you got a better deal, and you say, no, I want to do it for someone else. So I understand they use language like involuntary servitude, but is it? Isn't this what we agreed to? And there's no suggestion that it was by fraud or duress or force. You agreed you'd work for me for a year. Why shouldn't you? So I think part of the argument is involuntary servitude, but I think we can undercut that. There must be other arguments against it. Did you do the Paint My House case? Right? So what's the deal? I'm looking for the Geneva says she'll paint my house for $100. But she says, you know what? I made a bad deal. I'm not painting your house for $100. I say, no, Geneva, you're going to paint my house for $100. And I'm going to go to court and get an order of specific performance for Geneva to paint my house for $100. Why shouldn't the court specifically enforce the terms of that contract?
Something to do with like the resources are like better.
Something to do? You remember
Yeah.
everyone breaches, but you don't remember this?
Yeah, no, I know.
Yeah.
Well, everything's really hard to research.
Go ahead.
So basically, contract, if I remember correctly, said unless it's something unique service, then you can't really, the courts can't really enforce, like, and judge how well the performance.
Okay, so now we're back to life again. So there are problems not just with this notion of involuntary servitude, but how do we engage, how do we evaluate appropriate performance with the terms of the contract, right? Because if I force Geneva to paint my house, it's not going to look very good, is it? No, right? If you force me to make you that wedding dress, you're never going to want to wear it. No, right? I mean, but isn't that part of the problem with specific performance of personal services contracts? Is I might be able to theoretically force the person to do it. Let's be honest. You force me to paint your house, make your wedding dress. Fix your car, fix your car. Good luck driving that car, wearing that wedding dress, or looking at that purple house of yours every morning. There's going to be problems with then when we try to judge and evaluate the performance of it. We saw this case with some of the star athletes during the period where the USFL was poaching players from the NFL and the like, and they said, well, no, I want Flutie back, or I don't want Flutie, or this one or that one. You say, well, Greg Flutie can't force the USFL generals to make him play quarterback because generals don't want to see how he's going to be throwing the ball he's not happy. And we have the same thing with respect to TV and radio people, newspaper columnists, that type of thing happens, and it's as much with performance. But he still has he still breached the contract? Okay, I can't get him back. Can I get an injunction, though, stopping him from working for anyone else? I mean, you agreed you'd work for me for the next year for $50,000. Okay, you've got a better deal. And I can't get you back. I understand the argument. I can't force you to work for me. But I damn well can make sure you don't work for anyone else during the period. Can't I?
No.
What do you mean, no?
There has to be no adequate remedy at law. They can be paid damages for the money that they lost on him. They can quote.
But can I? I mean, so damages are going to do me enough here? I built him up to be a big star. Now he's going to take that brand, bring it to a competitor in the same market as me. How I'm going to be?
They compete for money.
Huh?
They compete for money.
But how do we gauge what I've lost there in monetary value? Because when we now start to think about no adequate remedy at law, and that is the argument we need to take, you're absolutely correct. What we oftentimes look at in the modern cases is that money won't be as complete and adequate a remedy as the injunction. I mean, are you really going to be able to establish with some level of certainty how much the damages are that you've suffered as a result of Warner Wolf traveling down the street and now working for a major competitor? You're going to be able to show what the advertising loss is, or the loss to brand and all of that? Because I think you're going to have a tough time showing what the losses are.
Yeah, that's what they said. There's no real injury here except the competitive edge loss. You know,
But isn't that a big one? No? Because I don't see why I shouldn't be allowed to prohibit him from working for someone else. If you guys had a non-compete and you wanted to go work for your company's competitor, didn't we see this in the case where they dragged the poor guy out from California to Kansas? And then they said, okay, here we're going to sue you here, and we've got an injunction. So they did, in fact, prohibit it. Go ahead.
Yeah, but he never like expressly agreed, or there was no trade secrets being lost. You know, there was nothing to that effect. There was no, he didn't commit any other tortious act. You know, therefore, generally, injunctive relief wouldn't, be at the behest of the employer.
And his contract was over. The time of employment was done.
So all he did was breach the provision with respect to allowing me the opportunity to try and keep him here.
Right.
Obviously, he doesn't want to stay here, so I guess I'll be limited to money damages for the provision of not honoring that part of the contract. But I'll get money.
Only good faith negotiation.
I'm sorry, go ahead.
Only good faith negotiation, right? Not the right of first refusal.
That's the part he violated, right?
Right, just good faith.
So so I do get money, but I'm not likely to prohibit him from working for the competitor. How would you value the money then under those circumstances? How would you come to a decision about how much money they've lost as a result of this? Because I think that's going to be tough to value. If it's not revenue loss from ads and stuff, and maybe it is. Go ahead.
I think that's the only way that you can assess it, is try to see what ads you've lost in his slot, and do some kind of discovery to find out what they've gotten for new ads since they've acquired him in that slot. That's probably the only way you can do it.
You guys don't think it's fair to force to keep him off the air there for a period of time? Just other than the 60 days that we looked at.
Well, they want you to keep him off for years.
I think only for the duration of the actual contract.
The provision, what it said, that for 60 days thereafter you can't work for anyone else. Is that right? Is that wasn't it 60 after, or was it 9? It was a short, relatively short period of time. 90 days in the same market, right? So that they'll be able to get, but beyond, and he wasn't doing that at any rate then. If you had this client come to you, you would all feel relatively comfortable finding the loophole? Because I could see justifying it one way. ABC had lawyers here too, right? And if ABC wanted to have an exclusivity during the entire period of the contract, they should have negotiated it, paid for it, and written it that way. I mean, I could see satisfying my conscience by saying, well, it's not what they asked for, it's not what they said. I could also see being a little troubled that you're clearly, as Karen pointed out, violating the good faith of the provision that was written, no? Let's talk about, oh, it's not yet. Let's talk about Vanessa Redgrave and the VSO. But again, what we're seeing, what we saw in the first case is the problems with respect to the enforcement of personal services contracts and the like, both for the argument about the involuntary servitude aspect and also the problems with the provisions of compliance with the order. Vanessa Redgrave would like to play for the BSO, to perform for the BSO, I should say. And simply was exercising her First Amendment rights, and she'd still like to perform for the BSO. Why shouldn't she get to? Why shouldn't she be able to demand specific performance? Like if you or I were picked to perform for the BSO, my guess is our stock would rise a little bit, right? We'd say, you know, I'm playing with the BSO this weekend. And certainly your family would be more impressed. I would be more impressed.
But they were willing to compensate her for the contract.
The money's not going to make her whole, is it? I don't want the money. I want to play for the BSO. I grew up here all my life. Now I get to perform for the BSO. That's a bucket list thing. Not mine, but maybe yours. I got a better. No, but right, it's someone's bucket list stuff. And now you're gonna say, no, we'll give you some money. And 25 grand is not nothing either, right? I think that's what the performance fee would be. So it's not nothing, but that's all I have to give you. Here's your money, see you later. Because she would like specific performance, right? And if you look at the terms of her suit, not uncommon at all. We've talked about this, and I really want you to start to see that when we see people actually filing complaints, that what we try to do is put a number of different legal theories within that complaint that have the ability to be pled, that the likelihood is there'll be some additional support for during the course of the litigation, and that hopefully with some evidence you have a chance to succeed, especially claims where there is statutory either multipliers of damages or the provisions of attorney's fees. When we plead those claims for, say, violation of our civil rights and the like, that changes the dynamic a little bit about the value of that case from settlements purposes as well, because if I'm successful in obtaining a judgment, then the attorney's fees provisions, attorney's fees in cases like that, or really in any piece of litigation these days, are likely to be substantial if it's been reasonably litigated. And so if you're going to force me to go to trial, then that gives me a significant leverage in recognizing that that there may be a really a bonus of a recovery there, which by the way, that has to be negotiated and decided what you're going to do with that provision in a lot of cases where you think that there is an award of attorney's fees. By that, what I mean is, suppose you took the case on a contingent basis. So it means you get a percentage of the recovery. Well, if there's statutory grant of attorney's fees, there's a question, or at least it's a question for discussion, who would that award belong to? Now, case law says it belongs to the plaintiff, it belongs to your client. Well, like all the rest of it, we can decide whether I get a piece of it or all of it. And so there is an ability to take not just a contingent fee, but to have some agreement that if there's an award of attorney's fees, that belongs to me, or 70% of it belongs to me, 25% belongs to you. And that's something you need to think about in some of these cases early on, obviously, because you have to enter into a client fee arrangement. But, and that can become a real bonus in the event you have to litigate the case to verdict. because suppose you do, then you get both a third of whatever it is, plus the award of attorney's fees belongs to you. The award of attorney's fees in a case that goes to trial of any significance can easily exceed hundreds of thousands of dollars. You put in 2,000 hours on a case for a couple of, over a period of a few years. What's your hourly fee? Pick a number. 300. What's 300 times 2,000? Beach house. Right? So you need to think about that. And so that has to be, well, listen, if we go to trial, right? I mean, and that's the thing, is if you're going to make me go that far, then the fact is, I put an enormous amount of time into it, and someone's got to pay. And so if your client understands it, and by the way, the risk is, if you're going to have to take it to trial, it could be zero as well. So you are shouldering an enormous risk with a case of that type as well. But that gives you leverage at the end of the day as well. But here, she's hired the big boys. She's paying cash, and she doesn't care about it because she frankly has plenty of cash. So she, by the way, justice was served, defense verdict in Providence, Rhode Island on Monday on that case I told you about where I was sued on behalf because of an accident by one of my sons. But at any rate, back to our story. So she's got various theories. All she wants to do is play for the BSO. Why not? Why can't she get specific performance of that agreement and let her perform for the BSO? Doesn't she have First Amendment rights? No, she doesn't. How come?
She's.
No, go ahead. You have it.
She's representing something that's kind of distinguished, and you can't just kind of run around and say crazy things to embarrass them and expect to be retained.
Well, let me ask you this. Even if they're not crazy, they can decide who gets to represent them or who they associate themselves with, period. I don't like what you said about Fred. I don't like what you said about dogs. I don't like what you said, period. Out you go. And as long as I pay you, you've got no recourse.
Well, that's true with most of us where we work. You can't say, I mean, if I said something inappropriate at work, I probably wouldn't be asked to come back, so.
Well, well, but what if you said something that you deeply felt, but that your boss didn't agree with? That doesn't matter? Your boss can still say, Mike, go on. Even if the person, I don't, so.
You don't have First Amendment rights privately. There's no state action. That's what they're talking about.
So if there's no state action, and my boss doesn't like what I say, your boss doesn't like what you said, you're gone, and you certainly don't get to keep your job. Maybe you can sue for damages, but don't expect you're going to be returning to that job next Monday, because you can't go, even if they may have violated your constitutional rights.
Right, constitutional rights aren't applicable to private entities. It's only.
And the BSO, we're all very comfortable, is clearly a private entity. What about like a state college or university?
It's different.
It's different, because it's an extension of the state.
Okay, so if I said something, I'm now employed by UNH, and I say something. They say, Mike, no, you're done now. You're fired.
Unless you're under contract or if your employer will.
I'm still out.
Yep.
Okay. Could I get specific performance? Suppose I'm a tenured faculty member. Can you force them to take me back? They say, no, they can't force you. You can't get specific performance of a personal services contract. We'll give you money, but they don't have to take you back. Is that right? Huh? Go ahead, what?
I know, I said I feel like that doesn't sound right, but I don't know.
Well, but she had a contract to do this performance, correct? And she said, I still want to perform. They said, well, here's your 25. She said, no, I want to perform. And she can't get specific performance in the agreement.
That was because of undue hardship.
Say what?
Wasn't that because of undue hardship on the Boston Symphony?
But what's the undue hardship on the BSO?
Because they would have to pay hundreds of thousands of dollars to like rent out a concert hall, in multiple locations, and then they have to sell all these tickets. And
No, but wait a minute, they're not multiple locations. They were gonna, they have the place, they had scheduled her performance. Well, why did they cancel it? It wasn't that just that they didn't like what she said. What were they worried about?
She embarrassed them, and people won't want to come.
Not people won't want to come. She embarrassed them, and they were threatened by who? It's not just security. What is it really about?
Benefactors.
The benefactor said, we don't want her there. And if you want our money,
Right.
don't let her. And so they made a business decision that dump her, because we're going to lose more money in donations than this is going to cost us, right?
Which they had the right to do.
I don't disagree. They had a right to do. And so she's out, and she can't get specific performance because that's what they choose. As long as they give her what she's entitled to monetarily, you can't get specific performance of a personal services contract. That's the law, right? So, same thing for my tenured college professor. Mike, you have tenure? They shouldn't have fired you? We'll pay you, but they don't have to take you back. I mean, why is it different? If you can't get specific performance of a personal services contract, you can't get it, can you? You get damages. I thought that's what the language says. Go ahead.
Is it tenure a contract that you would be working for a certain number of years for them?
Yeah, for the rest of my life.
Right, so then, it's different than the other case where the contract was over.
But so, it is, but so then that means I can get specific performance of a personal services contract? Because I thought the language we're all seeing says no. No. So I decide, I work for UNH, and they say, and this fine law school down the road, Massachusetts School of Law says, we want to hire you. I've got a 10-year contract with UNH. I say, you know what? They're offering me a little more money, and I like the students much better. So I go to Mass School of Law. Can UNH bring me back then? Why not?
Just so everybody get a posted work somewhere where you don't want to work.
So you can't get specific performance of a personal services contract, correct? Not to paint the house, not to make the wedding dress, not to fix your car, not to force someone to work where they don't want to work, right? And in Vanessa Redgrave's case, not to force the employer to let you work, even if you want to, because of the problems with supervising performance and all the rest of it, right? Personal services contracts, as a general matter, are not capable of being equitably enforced. Now, we do sometimes will enforce them negatively, like in the non-compete situations and the like. Right? If you've got information and there's an agreement that carefully detailed the way it was supposed to work, then don't cry later on when we tell you you can't work for a competing computer company for 6 months or a year. And again, we'll look at the limitations, time, space, geography, and the like, industry. But the fact is that carefully drafted, those contracts will be specifically negatively enforced. I can't make you come to work for me, but I can get the benefit that you're not going to then bring that skill set during the term of the contract, or at least for some portion of that time, to a competitor, because that's what we bargained for. So she's just out? Huh? She got paid. That was all it took to make her whole. Well, she wants to play. Remember bucket list. There might be people there, but it doesn't matter what she wants to do with respect to the performance.
Yeah, but if you take the responsibility of undertaking a contract, you have to be, with the understanding that the company that hired you has a certain expectation as well.
But so I give up my First Amendment rights to speak?
It's a business of bargaining. You give up certain things to get that money. So if you want that bucket list to be fulfilled, then she should have been more aware, I think, of her actions until.
Well, I got to keep my mouth shut? Yeah. Yes. That was part of that. That was part of the deal here, huh?
Yes.
Doesn't the company have a right to hire people and portray itself in a light that they wouldn't be portrayed by somebody that like made a comment like
See, I think, I mean, and again, from a financial standpoint, the way it reads and the way it exists in here is that they stood to lose a lot more if they allowed the performance to go through, because the benefactors did not want to see her associated with the BSO. So they absolutely made a financial decision from the standpoint of that issue. Can I ask you, she got her 25 grand. Is the extent of her damages, or
they didn't dismiss the last complaint.
which one? Which was what?
Which was that they violated Massachusetts civil rights.
Right. She may still have some viable theories with respect to her actual damages. They're not likely to be contract damages because she's got what she was entitled to get. She's not going to get specific performance because you can't specifically perform personal services contracts like that. But she might have a viable claim under the Massachusetts.
Yeah, I was just going to say, I thought they remanded it they may have not been able to prove incidental and consequential damages. That's what they were going to go back for, but they denied the claims for intentional infliction of emotional distress, civil rights, and requests for specific informants. So it was incidental and consequential that they're going back for.
Right. The best she gets is to try and use the Massachusetts Constitution to see if she can potentially get some benefit there. But we're talking money because, as a general matter, equity is loath to enforce personal services contracts.
And what could she get? Could she get
Well, if she could show that as a result of this booking, she incurred additional, the Locke's booking, she incurred additional expenses, or I would argue on her behalf, or as a result of this, their cancellation, then others followed in sequence somehow and also canceled her, not for what she said, but because of what the BSO did, then she could argue that all of those are consequences of BSO's acts.
Hard to prove.
I think so. I think so. And again, you know, part of it's looking at this case, and most of you guys are too young. I mean, you hired Vanessa Redgrave at the time. You knew she was outspoken. So
I remember.
Yeah, I remember too. And the thing is, it's kind of funny for them not to have expected some controversy, and then as soon as it happened, to so completely wash the hands of it. But at the end of the day, if personal services contracts, if your equity has significant difficulties requiring them to be performed simply because how do we gauge adequate performance? So then she gets there and she gives a speech about everything they don't want to hear about at all. So, I mean, gauging, you know, the adequate performance, or the BSO says, we're going to let you have a speech, but you're going to give it for 1 minute, and you're going to do it during the 2 intermissions. So no one's there to hear it. She says, well, that's not honoring the terms of my contract. I mean, part of the problem is you can't judge the actual performance of the contract, not the performance of the performance, but the performance of in accordance with the terms of the contract fairly under those circumstances. You've got one last one here that's in this group, and then I'm going to ask you some questions about these reproductive technology cases that I want you to think about. Oh, and talk a little bit about, how many of you have planned to take the midterm on Thursday?
In class?
Yeah. That's what usually happens. Okay.
Like Redgrave.
Okay.
I just don't want it hanging over my head during spring break, so.
You can do all the questions before spring break if you'd like, Greg, but okay. I'll make sure. Someone will be here. Test is all done. Okay.
We have class Thursday.
No, you don't have class Thursday then. Ray does.
So the question to do midnight on the 18th.
That's what we said, right? The Monday. Did we say? Oh, we said the Sunday night at midnight,
So
which
it's
would be the 18th.
18th.
So don't enjoy St. Patrick's Day that much.
I got the NPRE, so.
What the NPRE is? What, the 17th?
Yeah.
Oh, so it's a day. So.
Yeah.
You know, someone told me, by the way, speaking of the MPRE, that there is a free online review by Piper.
Piper, yeah, that's what
and they thought it was really good and very helpful. PIEPER, I think, right? and they thought it was very good.
I used another one called Supreme Bar Review.
Oh, I've heard, okay.
Which I thought was great.
Okay, Supreme Bar Review is another one.
The pipe one's like
Is
an
that free
8-hour
too?
It's free.
It's like an 8-hour video online, the pipe
And
one.
someone, I was at one of the conventions, Kaplan has a free book,
Supreme Bar.
but this one has the, they have the lectures online, it's all online,
It's
so.
free. And the Supreme Bar, you can buy the book if you want it, but you don't have to.
So, obviously, if you've got the week off beforehand, and since this stuff is free, you might want to look into it and help yourself. Then you can party that night. Okay. So let's talk about the last case here. Then we'll talk. I want to ask you some questions. The only reason I added in this Florida Panthers Hockey Club versus Miami Sports Authority, and as you read the case or looked at it, you can see it really is a dispute concerning real estate, the lease and the like. And somehow they twisted the language and talked about it is specific performance of personal services. Because this is one of the few cases where you could find any language about the court requiring specific performance, but to me it's much closer to a lease or an occupation agreement which really is, it's not unusual at all to see real estate agreements specifically performed simply because that is a highly unique situation. And we can get, oftentimes we'll get specific performance when they're highly unique goods that were supposed to be either produced or exchanged. And then you may not in essence be able to cover by obtaining those goods elsewhere. And so this sort of bridges where I want to go with this, is that when they're highly unique goods, you've been capable of getting specific performance in the past, but when they're personal services, it's been really virtually never. But I wonder whether in the situation of highly unique personal services, whether you could get some level of specific performance. So with that in mind, I want you to start to think about if you were drafting these surrogacy agreements and trying to put the parties together. And I want you to look at this Johnson versus Calvert. I want you to look at Colleton versus Beth Israel. There's another case that I think is still in the package. It's not referenced on the syllabus, but it's the Bazanka case. And I really like the Bazanka case because that talks about, that uses the phrase procreative conduct. Procreative conduct in trying to decide who the parents are. Because there are situations, and if you read some of the articles I gave you as well, there are situations where if we go by biology, there's two people that are the parents. If we go by procreative conduct, there could be two completely different people who are the parents. And if we look at the wombs for rent situation, then we could be adding the third person into the mix as to where that will be implanted. And so there are potentially 5 or more people who potentially can claim being the parent of that child. And so that becomes problems both from the standpoint of what are the provisions within the contract that you think you could put in there if you had to write one. What are the provisions that you think the court would enforce? So it's not just what you could write, but what would enforce. And what contingencies are you going to worry about that should be addressed in such a contract that you're going to build? You know, when we buy and sell a house, we have all these contingencies about obtaining financing and room clean condition and home inspection and all the rest. Well, that's for a house. What happens with respect to the 9 months while this contract is going to be performed? Not maybe more than 9 months, obviously, at least at the outset. And then to what extent can we regulate the activity of the surrogate during that process? And then who gets to make the calls that may be necessary to be made depending on genetic disorders, termination of the child either because you're no longer interested in pursuing this agreement. And what if it depends on whose genetic material was involved as well? How many people get to say, and how are you going to work that out? And what activities are you going to restrict during the process of the surrogate? And what are your preconditions for entering into such an agreement as well? Meaning, should there be a psychological exam? Is it permissible to do this for pay? Where do you see what do you think the appropriate role of you as the attorney would be in this process? And is it simply just to advise? And I mean, are we going to look for these loopholes like Juan and Wolf did? Because this isn't just the contract for personal services now. This is probably the contract for the most intimate personal services someone could perform. So I'd like you to think about all of that as you look at these cases and read some of the articles, because we've had these cases already here in Massachusetts. I think, again, within the package, it should be the case from out in Worcester where the husband wanted to make sure, now that they're no longer husband and wife, that the embryos are destroyed, that he can't become a father after divorce. And I think, is the article in the package still the article called the Sperminator, where they extracted the sperm from them after death, right? Is that still in there as well? And I mean, really, if you think about it now, there are so many different ways that the science is so far really beyond the law that we've got to figure out, you've got to figure out how this all applies and what your role in it is. And I think there's some really great issues for you to think about and start to be involved in as well. And certainly from the standpoint of covering your own backside on it, Jesus, there's so much risk, right? And then what are the damages, right? So, I mean, because a lot of this is drafting, and a lot of this certainly is making sure they're aware of the risks. But I'm not even sure how you cover all the potential risks. But if you intend to be involved in it, you better sit down and really figure out it and research it. I don't mean just sit there and figure it out yourself. You've got some real issues. And then, no matter what we write, we have this horrible question about how are we going to enforce any of this. And so I want you to think about that, because I've got some even, I think, probably more difficult questions as we go. Is with respect to, can you actually, I'll just ask quick so you think about it. Can we actually tell the surrogate that they give up the ability to choose whether to carry that child to term or not? It's someone else's choice? Don't just react instinctively. I need you to think about it, okay? Because, and does it make a difference whether I'm paying you for that choice or not? Or so the surrogate, 20 weeks in, could decide, you know what, I'm out. I'm going to Vegas with my boyfriend. I'm done here. Because if that's possible anyway, well then how do I get this agreement specifically enforced? We're 20 weeks in where, what, that's not even halfway, is it? Oh, maybe it is, right about halfway. Right, 30, what do we got to get to, 30, 38 or 37, somewhere around there? Huh?
I was going to say, there's on the other prospective parent, there's a lot of reliance and expectancy. I'm sure they've prepared a ton of stuff, and I mean, I don't know.
Well, it's not just that, it's the emotional investment, right? That's my child now. So, you know, I want you to think about it, because I want you to look at the articles. I want you to try and figure out what you think we can do, and then start to think about how do I ever get a court to enforce this if it goes bad? Because that's what we're worried about. That's what we always worry about. What's the worst case and how can I protect it? And I mean, money damages aren't going to make anyone whole in this case, appears whatsoever. So at least I got one down. But I don't know how we enforce it either when we look at traditional equitable courts as to what they do. And how do I even enforce some of this? So you can smoke and drink heroin? So I'm going to be able to restrict what it is you can and can't do. Think about it. We'll talk about it next time. And I think the appropriate place for the jumping off is to start to think about it in the traditional context of personal services contracts and specific performance. But I also think one bridge I would make is, well, at the minimum, we're dealing with a highly unique good at the end of the process, and highly unique goods, one can generally get specific performance on. So think about it, we'll talk next time. Enjoy your break, and someone will see you Thursday, right?
I guess I'll just do the question.
No, you don't have to.
It doesn't make sense for me to be the only one here to do it, so I'll just.
No, someone else.
Fine.
It's up to you.
I'll just do the question.
Because I've got the test is done, but you know.
I'll just do the question.
Okay, so everyone's doing the question?
Are we doing them through section 9?
Yes, this is section 9 today, right?
So we don't have to do all. Oh,
No,
it's
no,
not all.
absolutely not. No, it's
Up
it's
to
not
Section 9.
up to section 9. Okay?
So to just answer them, are they, I mean, are they one-word answers? Is it?
No. No. They're.
Is it similar to the sheet that you gave us for the civil procedure question, 103 questions?
They're like
Is it, yeah?
They're like short answer and long answer.
All right, well, I haven't.
Figure like an hour and a half for each one. For
Each week.
Each section.
Listen, the test is done. I will have, see them at the front office if you want to take it, and we'll find someone to do it. If you two changing your mind now again? Okay, you're good? You're all good?
We'll do it online.
Okay, good. Okay. It's good to have, let me tell you that, that's the other part of it. It's good to have that done for the final, because that information is mostly important stuff we've done up to now.
Which actually,